Let me go ahead and get started. Welcome to today's program with the Knoxville Bar Association. I'm Marcia Watson. I'm the director, and I'm excited to offer this program to you virtually. We've had much success with this program at both law schools in the past, and at least we're trying something different in 2020, and we are recording the program today, so it will be available on the KBA's YouTube channel. Let me go over a few housekeeping items before we get started. Feel free to use the Q&A button at the bottom of your screen to ask any questions. If you want your question to be submitted anonymously, just click that option. Today's program is sponsored by the Diversity in the Profession Committee, and please make sure to complete the evaluation that was included in your confirmation email. We want to plan some additional programs for law student members, and your feedback will be very helpful in our planning. I'd like to introduce Keith Burrows, who is our speaker for today's program. Keith received his bachelor's degree in accounting and his master of accountancy with a concentration in taxation from the UT College of Business and his JD from the UT College of Law. Keith is a shareholder at Edgerton, McAfee, Armistead, and Davis, and served as president of the Knoxville Bar Association in 2018. He's been practicing since 1990 in the areas of estate planning, trust, probate, business organization and planning, and trust and estate litigation. Keith is a frequent speaker, including estate planning and administration, to both professional and lay audiences. I always say that Keith and I grew up together because we started in the bar at the same time. So we're celebrating 30 years. So pretty exciting time. Keith's one of my favorite people. He's just one of the nicest people that you will ever have the chance to meet. So I hope you will have a chance to meet him in person one day. And with that, Keith, I'm going to turn it over to you.
Thank you, Marcia, and welcome, law students. And it's my pleasure to spend a few minutes today talking with you about the economics of practicing law. And I realized early in my career that folks that have undergraduate or graduate degrees in business that are also lawyers are kind of a rare breed. And so a lot of us, a lot of practitioners do not have the business background or financial background. And so this is not only a good topic for law students, it really is a good refresher for a lot of my colleagues. So the first thing I want to touch on is a comparable buying power analysis to what money in Knoxville, Tennessee would buy, and compare that to what an equivalent amount of money that would be required in another city in case you're looking to possibly take on employment in a city other than Knoxville. For purposes of my analysis, I used an assumed income for Knoxville of $60,000. So if you wanted to take a law job in New York City, in Manhattan, with a comparable buying power as what you would make in Knoxville, it would take almost $188,000 of income to live in Manhattan and have a lifestyle that you could have for $60,000 in Knoxville. Washington, D.C. would be $121,000. Chicago, Illinois would be $89,000. Dallas, Texas, $81,000. Metro Atlanta, $76,000. I think this next one's an outlier. Nashville, Tennessee, $69,000. My son lives in Germantown, which is just a mile north of downtown Nashville, in a part of the town that's being revitalized, and he has a 720 square foot condominium, loft condominium, one bedroom, that he paid $180,000 for 4 years ago, and that same unit is now selling for $360,000. So I think that's off a bit. But anyway, there is a website that you can go to that I use to gather this information. And it is at the link that's in my outline. Shucks. go away. It's NerdWallet's cost of living calculator. And so you can just put the amount of income you might think you could earn in this market, and then put in another market that you want to go to and see what it would require to have similar income. So in San Francisco, California, it would take $147,000 to have equivalent buying power of $60,000 in Knoxville. But if you go to that link, you'll see that it's pretty handy, and you can use it to analyze where you might want to go to work. Next is another helpful link that allows you to compare whether you should lease a piece of equipment versus purchase the equipment. And it's at this www.calcxml.com, and actually just I just typed in sale or purchase versus lease calculator, and this came up. And so in that, on that website, you can go in, and I did an illustration based on a real life situation in my law firm. We needed to buy a new copier, scanner, printer, color and black and white last year for our office. And the price of that piece of equipment was $9,000. It has an assumed useful life of 5 years or 60 months. And so I amortized the, or did the calculation on the analysis over a 60-month period. Assumed sales tax rate on the Tennessee state income tax rate is around 6%. The local tax rate's what makes it go up to 9 3/4. And I'm assuming that the equipment has no residual value at the end of 5 years. And I don't care what the computer or copier salespeople tell you, I have yet to find a copier, scanner, printer that gets high use that'll last more than 5 years. The other thing you want to do when you're negotiating that not only is the lease versus the actual cost of purchasing, but you want to negotiate a fixed service fee per month for the life of the copier printer, because if you go past a year or two, the copier companies typically want to start inching up the monthly service fee that you pay. Now, in the lease analysis, I assumed that the copier company, if they leased the product to me, they would want a 12% rate of return on the lease with no money up front. And on the purchase or buy analysis, I assumed for purposes of this illustration that I could go to the bank and borrow money at 5% interest over the term of the life of the copier printer, which is 60 months. And I'm assuming there were no other fees to be paid. And so once you put in those parameters into this calculator, you hit calculate, and it will summarize for you what the actual cost of the lease would be versus the cost of purchasing the equipment outright. So under this, and with those parameters and assumptions at a 12% rate of return, the monthly lease would be $212, and over 60 months you would pay $12,733 for a $9,000 piece of equipment. If you were able to borrow the money on 60 months at 5%, then the monthly amortization on the purchase price would be $180 or $10,802 over a 60-month period. So with these assumptions in place, it's clear that the better arrangement is to buy it outright. Now, you can tinker around with these rates of return. For instance, if the company only wanted a 10% rate of return on the lease, and you calculate that over again, then you'll see the price will drop to $203 per month. So depending on how they price the copier, printer, scanner, or any piece of equipment for that matter to you, you can back in by playing around with the assumed interest rate to ultimately determine what the actual cost of the product is going to be. Now, going back to the outline, one of the things that I realize a lot of new lawyers do not know much about is how to calculate operating expenses and cash flow needs for the law firm operating budget and the cash flow is key concern, because if you don't have cash, you can't pay people. So I'm going to have to blow this up just a hair so you can see it. But basically what we have here is just a month-by-month law firm operating budget. And if you've never done budgeting before, it's a good time in life to start, because this budget, what I would do if I were creating this, I would go in first and include the costs or expenses of operating the law firm, such as rent, payroll taxes and unemployment taxes, insurance such as professional liability, property and casualty, and general liability insurance, the fees that you pay annually for your law license to the BPR, a bar association memberships, continuing legal education costs, professional association memberships, and then different types of communications. For a lot of you, you may not know what a landline is. That's the old kind of telephone where you actually pick it, it sits on your desk and you answer the phone connected to cables. Your cell phone, which a lot of folks have gone to, not always the best solution for a law firm. Advertising costs, computer networks, those can be quite a big ticket item, including your electronic system monitoring, so your security and safety software, your cloud storage cost, photocopier, scanners, printers. We still haven't gotten away from those pieces of equipment. We're not truly paperless. The cost of internet connection, which in a commercial setting can be a fairly daunting cost because of the amount of volume and the size of information that you're sending back and forth. You need a really big pipe coming and going in internet connections. And then your service contracts, copiers, computer service contracts, telephone systems, things of that nature. And then you probably would want to, if you're a small firm, you probably aren't able to pay for a full-time accountant. And so a lot of people outsource to a CPA. So you'd have that cost along with office supplies, offsite storage, postage, courier and transportation costs, health insurance, accounting software licenses, other software licenses. If you're an LLC or a corporation, you would need to budget in franchise and excise taxes, property taxes. Locally, the local government will tax the value of your tangible personal property, which is all the stuff inside your law office. Westlaw or LexisNexis, parking, post office box, computer equipment. And those are just the more common types. And then once you figure out what that cost is, you also need to then move across the year each month and know, and anticipate what's going to come due in what months. For instance, professional liability insurance, the carriers require that you pay the entire annual premium up front. So they don't let you pay that typically on a month-to-month basis. They'll factor it to a finance company. And if you do that, then you're going to pay a substantial interest rate on that payment. So the professional liability is something that I've historically saved up money for and try to budget for it and have that much cash flow available to pay it in a lump sum to save money. But this is a good exercise. It also helps you figure out what my revenue stream should look like. If you know what your expenses are going to be, then in order for you to make money to take to the house, you need to collect enough revenue in fees and other income to cover the operating expenses and have money left over to live on. So this is a very critical exercise for any law firm. The other thing that you have to learn to do if you're going to get paid on an hourly basis by your clients is you must enter your time and expenses each day. Altman Weil, which is a company that does lots of surveys for law firms and law firm management, indicate that if you wait more than a day to enter your time, let's say you wait till tomorrow, the next day, you'll lose 15% of your time. If you wait till the end of the week, you'll lose up to 20 to 25% of your time. If you wait till the end of the month, you may lose close to 50% of your time. It's just impossible to remember what you did every minute of the day if you're not tracking it as you go along. One of the tricks I use is at the end of the day, I go back and look in my email inbox and my outbox for anything that I received that was client driven that I had to respond to and make sure that I captured all of that time as well. If you have a time and billing software program, we use one called iManage. Oh no, I'm sorry, Intap. In our firm, I manage is our document controlling software, but Intap is something that actually monitors my activity. So if I have a gap where I'm not doing anything on my computer, I'm not on the telephone, it'll tell me that I had a gap in my workday, that I wasn't doing anything, that the computer could document and figure out what it was. But if I'm working on a document or I'm on the telephone, it'll tell me and keep track of that. So at the end of the day, I go back and review that activity log and to try to make sure I captured all that time. And as one of my mentors used to say, bill it and don't kill it. So get paid for the work you do. Another critical part of law firm management and practice management is to review something called an aged accounts receivable. So in my practice, by the 7th working day of the month, we have kind of an internal policy that every file that can be billed for work done in the prior month or prior months should be billed out by the 7th working day of the month. And we incentivize that with our lawyers to encourage them to do that. And then once those bills go out, you don't automatically know which ones got paid. So periodically what I do is I have our accounting person send over to me an aged accounts receivable report. And here's an example of one that shows over here the client identity, and I just numbered them here. And then the first column is the total outstanding bills for a responsible timekeeper, me, which would be $38,400 at the point in time when this report was pulled. And then it shows you the bills that have been out less than 30 days in this column, then bills that have been out for 31 to 60 days that have not been paid in this column, and then the bills that are out over 61 to 90 days in this column, and then anything 91 to 120 goes in that column. And then you'll see these are the stragglers. These are the people who never probably intended to pay me to start with. They let me do the work, and even though they agreed to pay the fee, they didn't. And these are probably real old and never collectible. Your objective is ideally to collect in the first 90 days. And once they get out past 90 days, it's less likely that you will ever get paid. So this is something that I do twice a month, just randomly pick the day and look and see who has paid and who has not. And so those who do not pay within the first 30 days, then in that 30 to 60 day time frame, I send them a soft reminder bill. It's literally a copy of the previous invoice with a blue stamp on it that says reminder. And it's the exact copy of the bill we sent them originally. We also keep track of who pays best how. So my legal assistant is wonderful at keeping track of, does a client like to get a hard bill in the mail, or do they prefer to get an electronic bill by email? And so some of my older clients who are accustomed to paying paper bills will mail the bill to them, the invoice, along with the return envelope. And it's amazing, it'll come back very quickly. Other folks prefer to get it electronically so they don't mislocate it or lay it somewhere and not know where to get it. Then the second thing we do is when a client's bill gets into the 60 to 90 day category, then we send them an accounts receivable reconciliation letter that basically shows them their payment history, copies of all unpaid bills, a return address envelope, and a strong encouragement in the letter to please timely pay their bill. And that has a high realization rate if you stay on it. If you wait until after they're outside the 90-day category, then they're not as responsive, usually because you've gotten everything you're going to get for them and they've forgotten who you are. And then it's really important to analyze your collections by originating attorney and working attorney. What I mean by that. So an originating attorney is the lawyer who got the case in the door, but the lawyer may not have the necessary, I'm sorry? The lawyer that originated the file may not have the expertise to actually work the file. And so most law firms have accounting software that will track the information if the account is properly coded when the file is open. It will have an originating attorney and a working attorney. And so a lot of times law firms will make arrangements between their owners to where if I originate a file, but I ask one of my partners or an associate to work on it, then the collections are allocated between us based on the originator gets a small percentage of the collections that other people work on and collect. And then the actual working attorneys get the vast majority of that income attributed to them. And so it's a nice way to give credit for getting the file in and also giving credit to the person who does the work. And I categorize these lawyers in 3 different categories. They're called grinders, minders, and finders. The grinders are what most of us were or are when we first start practicing law. We don't have a great client base. We're reliant upon other people to send us work. And what we do best is grind out the work and do the work and do good quality work in a timely fashion and get it out to the clients. Minders are lawyers who are good at doing really good work and doing the grinding work for a client, so much so that the client likes them, and the next time the client has another legal matter, will come back to that lawyer, even though it wasn't necessarily the originating lawyer. And so I call those lawyers minders. And then the ones that we probably all know about are the finders. So it's the rainmakers, the ones who bring business to the firm. I've been blessed in my career that I've done all 3, still do all 3. I bring in a lot of work, but I also do a lot of myself. But I'm also able to bring in work that fills the bucket of my colleagues who don't have as many legal matters of their own, that I can help them increase their revenue by assigning work to them. So all of these categories are critically important to a successful law firm or law practice. If you're fortunate enough to be all 3, then you got a little hand up in that you can have more autonomy in determining what cases you want to take and which ones you want to hand to other folks. One of the things I really encourage young lawyers to do, and it's really takes a lot of discipline, but if you're doing flat fee work and you quote, I will do this engagement for X number of dollars, and in that scenario, the engagement agreement is clear that upon receipt of the payment from the client, that it is an earned fee and you don't have to account for hours you spend doing the work. The temptation is to put that in your operating account and spend the money. I would encourage you to put that money into your law firm trust account and then keep track of your time for how long it actually took you to do the work and document that. And then when you get ready at the end of the engagement to pay yourself out of your trust account, see if the flat fee you set is realistic compared to the amount of time it took you to do the work. I also recommend doing the same thing for retainer fees with kickers placed periodically. I would schedule out what I think the engagement, how long it would take, and different progress points along the way. And then when I meet those progress points, I have a predetermined agreement with myself about how I'm going to pay out and how much, depending on the progress that's made. And then I've also had cases where we have hybrid fee arrangements. So my hourly rate today is $300 an hour, but it would not be uncommon in certain cases, especially potential contingency trust and estate litigation cases, where I might take that case on a $200 an hour rate, and it doesn't matter who works on the file, they would be billed out at $200, but then have it count against a percentage of collection. So if I said, I'll take this case on a third, and we collect $1 million, then I would get $333,000 of that from the client's recovery minus whatever they had paid me to that point. So if they paid $20,000 or $30,000 to that point, then they would only owe the difference between $333,000 and what they minus what they had paid to that point. So that's a neat way too. Now I will take any of those $1 million cases y'all want to hand my way, because they're not on every doorstep. So I don't want you to get over enthused. One thing I want to make you clear to you is that the Internal Revenue Service is not your friend. You need to keep copious records of the time and billings that you sent out, and hopefully use a software package that will track your revenues and expenses and will create financial statements for you, such as a profit and loss statement and a balance sheet. You should keep detailed travel logs of the date, place traveled, the client matter, and a calculation of mileage reimbursement. There's actually a standardized rate the IRS lets you charge. I think it's currently about 57.5 cents a mile. But you're required to keep a travel log that says when you left your office and where you went and came back and what was the purpose of that travel. And if you can't prove that, but you've asked for a reimbursement and therefore a deduction for the law firm, and you can't prove where you went and what you were doing, then the IRS will just summarily disallow that deduction, which means now you're going to owe additional tax, penalty, and interest. So keep good records. If you're a small firm, one of the ways you can minimize some of your internal expenses is to outsource your monthly reconciliations and preparation of financial statements, and at the end of the year income tax returns to a CPA. So in my previous life, I was in a smaller firm that I created, and we really didn't have the need for a full-time CPA. So we would each month send out our records, our bank statements, our canceled checks to the CPA. They would reconcile them and create financial statements for that month. And they would charge us a very reasonable fee to do that was significantly less than having a full-time CPA on staff. Another neat technological advancement in the last 15 years is something called voice over IP. So if I get a telephone call to my desk and I'm not at my desk, and a client or colleague leaves a phone message, a voicemail, as soon as that voicemail is completed and the caller hangs up, I get an email to my inbox in Outlook, which also feeds to my phone Outlook access for my mobile Outlook. And I can click on that voicemail, the attachment to the file, and listen to what the message is that was left on my office number. And it's a wonderful way to track communications. If clients say, I left you a message and you never responded, well, you can go back, and if you don't delete those out of your telephone system, electronic VoIP mailbox, you can say, well, I've got every voicemail that I've received in the last 2 years and you didn't leave me a message. So it's a good check in that regard. Also, digital dictation. I don't have my dictaphone, it's in my briefcase, but I have a digital dictaphone that I can dictate a file or instructions to my legal assistant, or a letter or a document, and I can just connect it to a cable attached to my computer. I can download it to her dictation folder, and she can transcribe it. I can do that from anywhere. I can get a high-speed internet access point. And I can download it through my laptop or through my desktop. It is a wonderful tool. And I know a lot of folks, including some of my younger colleagues here in the firm, they type all their, most every document they do, they type. I'm not that quick. I think I top out at about 45 words a minute. And my most used key on my keyboard is my backspace button. In fact, it's worn off. I don't even see it on there. The word is worn off. I use it so much. So I'm much more efficient dictating instructions and documents and sending them to my legal assistant. Now, for over the last 20 years, the IRS has had a series of cases that have come down challenging the categorization of somebody as an independent contractor that the Internal Revenue Service says is actually an employee. A lot of employers want to identify their people that help them as independent contractors because in that case, the burden of paying Social Security tax, Medicare tax, and federal withholding tax all shifts to the independent contractor. So the independent contractor gets a check, and then they're responsible for paying 100% of their employment taxes and income taxes. Whereas if they're categorized as an employee, then the employer pays half of the Social Security and Medicare tax, the employee pays the other half, and then the employer is also responsible for collecting and remitting federal withholding tax. There was a 20 common law standard test that made a determination of whether somebody was independent contractor versus an employee. And so we've gone back and forth through the years trying to, oops, here we go. Arguing about those common law standards. It had a lot to do with whether the employer controlled when, where, and how the employee did with their work, whether the employer provided equipment and tools for the employee to do their work, insists that they work during certain hours. Those were among the 20 common law standards. Earlier this year, beginning in 2020, the IRS issued this publication 15-A, and it goes through great detail, gives lots of examples, case study type analysis of how the service would categorize people as either independent contractors or common law employees or statutory employees. And I would encourage you that you just Google IRS publication 15-A, and you'll go right to this document. It's a much better instruction tool for employers to not make the mistake of trying to categorize someone as an independent contractor when they really are an employee. And you ask, why does it matter? Well, if you categorize someone as an independent contractor and then the IRS audits your return, and the IRS determines that you should have categorized the person as an employee, not as an independent contractor, then you're going to be personally liable for the federal withholding tax that you should have withheld from the employee but did not. And you'll be liable for half of their Medicare and Social Security tax, which is 7.65%. The total tax the combined is 15.3%, with 2.9 of that being percent being Medicare and the balance being Social Security. But when you split the two down the middle, it's 7.65%. And so you could be looking at 7.65% of their payroll plus a minimum of 10% withholding tax, plus penalties and interest. And the penalties accrue at 5% a month, up to a cap of 25%. And then you add on top of that whatever the going interest rate is at the IRS at any point in time. And so you could find yourself in a pickle because you've paid all that money to the employee and now you get to pay it again to the IRS. So I would highly recommend that you put the bookmark on this publication when you think about starting to practice, and look for any updates. But in this, it goes through a lot of specific situations, and it's a really helpful tool. So I commend that to your reading. Going back to the outline. Oh, there we go. Sorry. All right. So one of the things, one of the exercises I encourage young lawyers to do is try to extrapolate what you want to make in income, and how do you realize that from your gross income to your net income that's available to spend. And so what you do is you take 100% or 1 minus the combined tax that you have to pay, which would be your federal income tax and Social Security and Medicare tax. If you're self-employed, you pay the whole thing. So you would add up those combined income tax and employment tax rates, add them together, and subtract them from 1. So in this illustration, I was assuming that the combined total of taxes will be 33% of gross income. So you take 1 minus 0.33 equals 0.67. And so that would be your rule of thumb to determine what your income has to be in order to end up with 67% of that number. So to do this math correctly, let's just use $100,000 as a number after tax that you want to clear. So you take $100,000 and divide it by 0.67, which would indicate that in order to make $100,000 net to the house, you'd have to make about $149,000 total. And to prove that the math works, you take 149,000 divided by 0.67, which is the amount of the total you would have left over after tax, and that gets you to $100,000. Now, where a lot of people make a math mistake is that they take 1 and add the tax rate to that number. So they would take 100,000 times 1.33, which would indicate that if they made 133,000, then they would end up back at 100,000 after tax. But that's not true. You got to remember you're grossing up by dividing through, not by multiplying by. So in that illustration, if you use this wrong math here, then you would only end up at $89,110 of after-tax income. So don't make that mistake. Also, when you're doing budgeting, you got to realize that when you determine a payroll amount for a particular employee, a salary or an hourly rate, you need to multiply that by somewhere between 120 and 140%. I used 130%. By the time you add in parking and bonuses and health insurance and other benefits, 401k matching, you'll find that you roll up to a bigger number than just the raw payroll. And for professional staff, such as attorneys, it can be even more, because you got to calculate in CLE, bar dues, professional tax, health, life, and disability insurance. So those are all things to keep in mind. Also, if you're looking for Class A space, Class A space in Knoxville right now runs about $15 to $20 per square foot per year. And plus, if it's a triple net lease, you would also be paying an additional amount per month toward the CAM, or common area maintenance, which includes property taxes, maintenance and upkeep, and insurance. And that's calculated based on the occupancy rate of the building and the percentage of the rentable square footage that you're consuming. Also, a lot of times landlords were going to want you to enter into guarantee agreements, personal guarantees, if you have a corporation or an LLC formation of your law firm, and they'll want the shareholders or partners to guarantee the lease. That's a negotiable term. And so a lot of times what I have seen people do is that they will negotiate that the guarantee will last as long as it takes for the total amount of accumulated lease payments to equal the tenant improvement budget that the landlord has given the tenant at the beginning of the lease. So if at the beginning of a lease that is $5,000 a month, the landlord agrees to include $100,000 tenant improvement budget, so the tenant can go in and fix the office the way the tenant wants. Then once a total of 20 months has transpired, at $5,000 a month, they would have repaid the full amount of that tenant improvement and then get off the hook. Other just professional recommendations is that, you know, the easiest way to be perceived as a lawyer is to look like a lawyer. So I highly encourage you, when you're first starting out, if you're a free spirit and you want to do it a different way after you get established, do it. But if you want to be a free spirit and you don't have a job yet, you're probably not going to have a job. So I would highly encourage men to wear a suit and tie. And don't get one of those suits that looks like it was painted on you. Get one with a little room in it, because you're going to be sitting about 90% of your day. So you want something that's comfortable. And then also for women, either dress or slacks and a blouse. Men, I highly encourage you to learn how to polish your shoes. And if some of you don't even own shoe polish, go out and buy shoe cream, not wax, and use an old t-shirt to apply and to buff off the dried shoe cream. And if you look over sloppy or overly casual, it may just very well send the wrong impression and people won't hire you. Men, go to a tailor shop where there's a true tailor who can help you pick out a suit, or women are much more, they're better selectors of clothing, even though they don't have tailor shops necessarily to go to. They tend to be better dressers. So look sharp. I also encourage you, start today to build a network. You have a network already, and it's the colleagues that you're in law school with. And so get to know one another and get to know what your respective interests are as far as practice areas, so that when you go out to start practicing and one of you gets a call in a practice area that you don't do, you'll know one of your colleagues to send it to. I also encourage you to get involved in your community. Our bar association, we have barristers for young lawyers. That is a very good organization, very active, and you can be a free member while you're a law school student, and participate in that opportunity. And also in our diversity program each year, we have a roundtable, and we have a buddy match program where you can actually get paired with a lawyer and meet before the fall program. If this darn pandemic will ever end, we'll meet in person. but there is no suitable substitute for face-to-face networking. And when we get back to where we can actually do that again, I highly encourage you to do so. Also, I encourage you to go to the Chancery Court and ask each of the chancellors to put you on a guardian ad litem list, as well as the juvenile court. And that way, when they have a case coming up with an incompetent, whether it's a minor or an adult incompetent, and there's a guardian ad litem needed to evaluate and report back to the court the circumstances, get your name on the list, and that gets you in front of the judges and get you great experience. And it's actually fairly rewarding, both personally and financially. Other admonition I would have is be hesitant on taking every case that walks in your office. And I violated that rule like crazy. I'm a second-generation lawyer, and some of my father's old clients who thought that they could get work done on a shoestring showed up, and it was very hard to condition them. And then there were other cases that came in that were just marginal, and I took them, and I realized later on I should never have taken the case. So remember, it is better to not do the work and not get paid than to do the work and not get paid. Also, if you have downtime in your practice, I encourage you to research a topic of interest that is timely or a new development in the law and write an article. The Knoxville Bar Association is constantly looking for authors to write articles for our monthly magazine called Dicta. There are outlets through the Tennessee Bar Association for publication in the Tennessee Bar Journal. If you're computer savvy and you want to start a blog and start talking about items of interest to potential clients, and you know how to push your website up the list of Google search options where it's high, very high visibility, do that. That's a great way to market. It doesn't cost anything but your time. There's usually no out-of-pocket associated with it. And it also makes you an expert. So it's a multi-win-win. And the best way to learn a subject is to teach it. I'm a firm believer in that. And that's why over the years I've taught numerous seminars to both professional audiences and to lay audiences. It just keeps me sharp and on task for my particular practice area. And so I encourage you to write and to teach any opportunity that you get. You will get recognition for it, and it will build your practice. Also recommend taking a non-lawyer to lunch, coffee, or drinks. When I first started, I knew I wanted to do this area of law that I call death and dying law, and help people plan for it and help their families through the process when a loved one passes away. And so I realized that probably my best referral source were CPAs, life insurance agents, financial advisors, and people in those areas that would have people with net worth that would need to have planning performed for them. And so I would periodically just call a lawyer. I mean, not call a lawyer. I'd call one of those potential referral sources and take them to lunch and ask them what they did and what kind of clients that they like to get in the door. And they would typically ask me the same question. And so we would build a little network there informally. And so when they had a person in need, they could, that I could assist, they would send them to me. Another encouragement to you is to turn off, not just turn down, but turn off your cell phone or completely silence it and put it face down on the table when you're meeting with anyone, especially with a client. It's rude to be glancing at your phone. If you absolutely have to take a call, excuse yourself and keep your phone on silent anytime you're on the job, and always while in court. I have seen colleagues who got busted in court when their phone rang, and as a result of all that, I never turn my ringer on. It's always silent. It probably drives my wife crazy because she's constantly having to just text me and I'll feel the buzz, as opposed to calling me because I don't always respond to the phone when it's ringing. So develop that habit, and develop the habit of not looking at your phone constantly, because that sends a bad signal to your clientele, unless you're waiting for a call on their matter, and that's an exception. So I would encourage you to create that habit. And with that, I thank you for your time. And if I can ask or address any questions that you might have, I'd be delighted to do so.
Keith, thank you. That was excellent. I have, uh, hopefully everybody will be able to see, I added the link to the evaluation in the chat. So if that's easier than pulling it up from the email, I would appreciate if everyone who participated today will complete the evaluation. And if anybody has any questions, please go ahead and put it in the Q&A. I don't see anything right now. Of course, you provided your contact information, and if anybody has any questions, I'm sure you'll be happy to speak to them personally. And as I said earlier, we're planning to put the recording on our YouTube channel. So if you want to let others know about this, we would certainly appreciate that. With that, thank you very much for doing this presentation, and I hope to see you in person very soon. Oh, let me see. Actually, we did get one. So somebody is asking what the average salary right out of law school is. Keith, do you have a feel for that? I know we did the economics of law office management a couple of years ago. And we still have that information available on the KBA website. That's the only resource that I know that's would list that information currently.
Yeah, I will tell you that that's something that we're trying as a firm to monitor all the time to make sure that our law firm salaries are in market. And what we've discovered is that the starting salaries for young lawyers is all over the board. And it's all over the board, not only in Knoxville, but regionally. Even some of the firms in Chattanooga are paying well over $100,000 for a starting attorney right now, which is when you start doing the arithmetic, they're doing that for some other reason than profit, because that it would be very difficult for a brand new lawyer to cover $100,000 of salary plus all the other costs associated. In fact, in the first year, it would be hard just to cover $100,000. So the law firm's making an intentional investment for some other reason. But I would say that in the Knoxville market, the starting salaries somewhere between $50,000 and $75,000. I know that's a huge range, but I think that that's a realistic range to expect. And you know, should be no surprise to you that the people who rank higher in the class, who are also engaging, young lawyers, will probably be at the upper end of that range and maybe exceed that by several thousands of dollars. And those who are lower in class rankings will probably not be a candidate for those higher paying jobs. And that's just, facts of life, unfortunately. But it really is important now for people coming out of law school to not only have really good grades, but also to be an engaging personality, and to and to really think about what you say and how you approach situations. Will have a significant impact on your job search, because unfortunately right now across the board it's a buyer's market. My wife was laid off from Regal Entertainment Group, and she was furloughed in March, and that furlough became permanent layoff in July. And she has applied for other executive positions since then at really good companies in town. One job, she told me that she really liked the description of it and everything. There were 170 applicants for that one job. So the number of law jobs, are not as plentiful right now. They're more so than they were 10 years ago, but it still is it's a tough market.
Good. And we received a note from Allison Starnes-Angley of LMU Law School, and she said that she agrees with you, Keith, and she was going to say 45 to 80 in Knoxville. Lower salaries are at the smaller firms, solos, and public interest positions.
Yeah, and if you find yourself in having to go and hang your own shingle, and I would encourage you to try to find a colleague to do it with, even if y'all don't share the money between you. But there's strength in numbers, and you need somebody to bounce an idea off of before you haul off and do something. It's always been, I've always worked in situations where I had other colleagues that I could go and bounce fact structure off of, and what I thought I ought to do. If nothing else, create your own network of colleagues in a similar practice area, and teach one another. That's a great way to learn.
Very, very helpful. Keith, thank you so much for doing this program. And I guess with that, we'll let everybody get back to their classes. And thank you very much for participating.
Thank you all.
All right, thank you. Bye-bye.